Hey, hello everyone. Welcome to my presentation on ethical dilemmas and complex issues. So today I'll be walking you through two significant parts of my presentation, and both of which captures the real life stakes of discovering and disclosing security vulnerabilities in the real world, where I would say where technologies, corporate interests, and individual rights can collide without warning. So before we dive into specific cases, let's take a step back and consider the broader landscape. Okay, so basically we're living in a era where digital devices and smart products they become part of our everyday routine, where it's whether it is Bluetooth, IoT devices, Bluetooth, lock, Bluetooth lock for your front door, wearable health monitors, and the gadgets that automates your home environments. So, on the other hand, these technologies promises us convenience and interconnectedness that would have been unthinkable just a decade ago. Okay, so on the other hand, I would say every innovation creates a new attack surface. As an offensive security researcher, I would say that. And security flaws can put people's data, finance, and physical safety risks, and often without them even realizing that danger might be lurking in the code of the device they trust. Okay, so in this video, I'm just focusing on two prime examples, as I said earlier, that actually shows how quickly a well invented research or employees can end up in a legal and ethical quagmire. Okay, so the first is Anthony Rose, who actually discovered a major vulnerability in Bluetooth enabled locks and faced moral dilemmas. Okay, sorry. So we should keep pressing the manufacturers to fix these flaws, or go to the public and risk being sued under the ambiguous hacking or defamation laws in the United States. Right? And the second example actually shifts us to a Canadian context where Salesforce Red Team developed a powerful internal tool, okay, essentially an automated malware generator, and then ran into a fierce corporate pushbacks and eventual dismissals when they attempted to present it at a conference. Okay, so these two stories will help us to see how the complex interplay or the intellectual property laws and consumer safety regulations and corporate policies can shape the fate of both the researcher and the general public. So in the final part of my talk, I'll plan to highlight the case study involving AI, okay, in the legal realm, illustrating that as our tools become more advanced, the ethical and legal questions we face might get more complicated too. Okay, so the key idea throughout this presentation is that ethical decision in cybersecurity rarely exist in a vacuum. Each choice interact with corporate strategies and potential lawsuits, like public safety interest and emerging technologies. So my hope is that by the end of this talk, you will see not only how these real world scenarios unfold, but also how professional frameworks can act like a compass and helping us to do the right thing in the field where right thing is not always crystal clear. Yeah. So without that broader context in the mind, let's shift to part A of the assignment. Okay, first I'll bring you to Anthony Rose, and it eventually becomes a serious risk to public safety, and which had to weigh his legal exposure against the moral stories, like to warm the unsuspecting consumers. So let's see. Okay. So, looking at Anthony Rose's experience, a case that perfectly illustrates the tightrope security research often walk when they discover a serious vulnerability, right? So if you glance at the slide in front of you, okay, you will see an overview of Anthony's finding. He tested 16 smart Bluetooth-enabled door locks, and only to discover that 12 were alarmingly insecure at that moment. So some used the plain text passwords that could be intercepted by some of the tools. Some allowed attacks to lock the legitimate homeowners, and a few even let someone remotely unlock the door from the half a mile away, I think. And for a homeowner who believed in the marketing hype about the convenience and security of a smart lock, that's that's a pretty terrifying discovery, I would say. So, what Anthony did next seems entirely reasonable. I mean, he reached out to manufacturers, but as you can see from the details on the slide, on only one manufacturer responded. Okay, like at the moment, only one, manufacturer responded as I think, and as you can see on the screen, in a constructive manner. So several other dismissed his concerns or remained silent, and one company even shut down its website for that, and yet kept selling the same vulnerable logs on popular platforms like Amazon and Alibaba, something like that. So it's not surprising that Anthony felt a moral pull to warn the public. I mean, worse still, local news began reporting a spike in robberies at home that used these kind of logs, including that criminal had already caught on. Okay, so right on that point, Anthony had to decide what he disclose widely to protect the consumers, or does he lie how low to avoid the lawsuits, right? So moving to the next topic are legal risks. Okay, so in the United States, vulnerability disclosure can become legally precarious. I mean, if a lockmaker chooses to interrupt Anthony's testing as unauthorized tampering, they might accuse him to violating the Computer Fraud and Abuse Act, or CFAA, which is which is the rule. So this law is broad enough that it can snare even well-intentioned research who poke around without explicit permissions. Okay, and on top of that, a manufacturer can threaten the defamation, or I would say uh, product product theft issues. Okay, so claiming that public statement about their flawed locks could actually harm their reputations or sales. And when you think about it, I would say there's a lot of potential liability for someone who's basically just trying to keep a family safe from the intruders. Another angle is consumer protection, and yes, Anthony might have turned to federal regulators of the U.S. Federal Trade Commissions (FTC), which can investigate companies that mispresent the security of their products, or perhaps the Consumers Product Safety Commission (CPSC) if there is a demonstrate safety hazards. Here the trouble is these routes do not necessarily shield the researchers from, civil suits, right? And I would say if even the FTC cracks down on the negligent manufacturers, Anthony could still find himself the target of the legal, intimidations. It's easy to advise, like, okay, well, just contact the authorization committees, authorities. But the real world, that is no guarantee of personal legal safety, I would say. And he's left waiting whether exposing the flaw to protect the public might backfire. Forcing him to defend himself in a court. And moving to the next topic, ethical dilemmas. So, from a moral standpoint, I would say Anthony Rose is torn between a desire to protect people, I mean, homeowners who assume their locks are secure, and fear that revealing too many technical details might actually help criminals. So, responsible disclosure standards generally recommended I would say, private head-ups to the vendor. I mean, which allows for a patch, I would say, and what we can say, and then a public release, okay, of that particular program or particular IoT device, whatever they are using. So, I mean, if the vendor doesn't respond to it, that is mean. I mean, they're secure. So Anthony tried that route actually, but most of the manufacturer refused to cooperate. I mean, leaving the homeowners in the dark. And now, if he goes fully public with the exploit specific, and so the criminals can exploit them immediately. And if he stays quiet, I would say more breaks in could occur as well. So he's caught in the place where ethical duty, and legal risks, collide. So that's the scene. And one often suggested alternative is, I would say, anonymous leak to the press or a consumer watchdogs. I mean, newspapers and something like that. Though that reduces Dan Anthony's ability to answer question or coordinate solutions. And another is a partial disclosure. So he might reveal that flaws exist, but without the exact details of how to exploit them. But even the partial disclosure can spark lawsuits if the law companies would want to silence him. So, while a coordinated disclosure approach is recommended by many security guidelines, but it doesn't fix the underlying reality. Okay, some companies prefer threat over corporations. So that was all for that. Now we're gonna talk about the recommendations. Okay, so one clear recommendation for Anthony would be, I mean, document every step he's taken, emails and attempt to call or meet with the companies, evidence trying to, lock vulnerabilities to actual, burgeries. I mean, this paper trail might help him. So, a good faith, right? And if particularly, if a legal dispute arises, he could also consider, reporting through a recognized vulnerability disclosure programs like HackerOne, like BugCrowd, and Integrity. Yes, we hack. There are a lot of vulnerability disclosure programs and bug bounty programs and platforms over there. So he could use that, and which actually, mediates between the researcher and the vendor, potentially reducing his direct legal exposure. That's how bug bounty hunters works. Okay, so regulatory compliance such as filling with the FTC or CPSC might also help him. And if a government agency intervenes, manufacturer could face investigation or sanctions for selling, I would say, unsafe products to every single person. So sorry, while it doesn't guarantee personal immunity for Anthony, it actually strengthens his argument that he was acting in the public interest and documenting everything what some call like lowering up make it hard for a company to claim he acted recklessly for maliciously. Okay, so that was all for the recommendations. Now we'll talk about the part two, Salesforce red teams, right? So let's shift to our second scenario. Okay, so picture yourself. I would start with with a simple example over here. So picture yourself working on a red team at a large tech companies. I mean, your daily job is to think like a cyber criminal, design sophisticated attacks, and then see how well your own employees' defenses holder. Like you are essentially paid to break things, okay, in the company, and company can build them back stronger. In this case, I would say the red team developed a tool that is actually called Meat Pistol, and it actually intended to automate the malware creation for the internal testings. Like the vision was straightforward by, I mean, quickly generating the new forms of malware in house. I mean, they could have discovered and fixed the vulnerabilities before like a real attack had the chance to exploit them. Okay, so moving to the next slide. So here it is a brief overview of how everything unfolded. Okay. Sorry. So after polishing meat exploit, Mid Pistol, the red team members thought, what if we share this with the broader security communities? I mean, imagine how much we could collectively learn from that. Initially, like it seemed that company was on board. They even approached conference talk. Like I was in a talk, Black Hat Hackers. Okay, and in that case, I learned a lot of things. Okay, so however, I mean, just before the event, a senior executive abruptly changed the course of ordered them not to present that thing or to release any code. Okay, so the red team convinced their particular disclosure, I mean, would do any harm. I mean, decided to proceed with the talk anyway. And albeit without providing the full technical details, unfortunately, that decision led to them being fired for a cause. I mean, losing shares and benefits, and finding themselves blacklisted internally. I mean, it's a shocking outcome, obviously. So let's break down exactly what happened through a Canadian legal and ethical lenses. Okay, so that was the thing. And in the Canadian settings, particularly in the province like Ontario, okay, so employees can terminate staff if they can establish, I mean, just cause. If it's a single cause, if it happens. So if your contract clearly states that any unauthorized disclosure or proprietary information can result in an immediate dismissal, or I would say if you defy a direct lawful instructions, sorry, it's actually legally difficult to consent to the firing. I mean, no one can stop that. So in this scenario, the red team members developed a meat pistol on a company time. Okay, using a company resources, which typically means Salesforce fully owned the intellectual property. Okay, so when the executives, I mean, reversed the decision of releasing mid pistol, the the corporate stance becomes no code to talk. But actually, the employees are still presented and of us get versions, and apparently believing that they were meeting the company halfway. So from Salesforce perspective, I would say that still constituted the insubordinations, right? So I would just say that they might argue that even the partial disclosure, I mean, compromise intellectual properties or brand reputations under Ontario's Employment Standard Act (ESA) or equivalent laws in other provinces. Okay, and these kind of company or the company should justify the termination by the showing that these employees violated confidentiality or direct floated management's order. Okay, so you might ask like how could they file for a wrongful dismissal possibly? I mean, but if the contract spelled out, I mean, that employee must follow the directives, I mean, related to the proprietary tools, Salesforce would have a strong legal defense on them. So now we are moving forward to ethical aspects, like ethical tensions. So the red team employees believe that, sharing meat pistol, even in the limited form, would benefit the security community, like offensive security community. The idea was to foster collaboration. If more researchers, could refine the tool, corporate red teams, everything might adopt advanced testing methods. Raising overall cybersecurity standards, I would say. And yet, critics points out that dual use nature of malware generation tool. Like, while it can help the defenders, it can also harm the malicious actors if leaked or it is misused. And here I would say, did the red team have the moral right to prioritize community gains over their employer's explicit instructions? Right. That's the one question I would ask to every single person. And another ethical point is loyalty versus transparency. So we often talk about the open source security tools as a way of improve best practices, but a large private corporation might see open sourcing and an internal tool, especially a malware frameworks. So as a public relation or a liability nightmare, if a criminal turns it against other businesses or individual, uh, would the original publisher bear blame? Okay, no, not at all. The clash in this scenario isn't necessarily about the right or wrong in the abstract sense, okay, but rather whose priorities take precedence, the public good or the employees boundaries, I would say. So moving to the next topic, here's the recommendations. So if we look over here, so how this could have played out differently. Okay, so our recommendations in thorough internal alignment well before any conference talk. In a large corporation, like clearance to speak publicly often passes multiple layers of legal and executive reviews, I would say. And as for the employee, the key lesson is that once an executive issues a direct order against releasing or discussing an internal tool, proceeding in the capacity can viewed as a definance. Okay, so even if they felt ethically justified, the reality of a corporate contracts and NDAs means the employer stance typically prevails. Okay, that's especially true if the tool is considered a proprietary intellectual property. So the red team members might have had other softer like disclosure avenues, like such a writing conceptual talk that never referenced actually code or hosting close technical stuff into that. So, but it appears everything happened too quickly for such compromises to materialize. Okay, and now moving to the next part, it's part B, cyber risk standards and the frameworks. So, as now, as of now we have examined the two very difficult but equally intrusive cases. One involving a researchers grappling with legal threats over Bluetooth lock disclosures, and another featuring corporate employees who clashed with their own employees' IP policies. It's only natural to wonder if there is a more systematic, less chaotic way to handle cybersecurity challenges. That's where the professional standards and the frameworks come into play. They exist precisely to reduce guesswork and the ambiguity, providing a consistent guideline on how to assess the cyber risks. Respond to the vulnerabilities and I would say document investigations in a manner that holds up under both ethical scrutiny and legal examinations. So let's take a moment to consider the role of these frameworks first. So imagine you are at a company where your team discovers a serious flaw in your flagship product, or much like Anthony Rose discovered in the Bluetooth locks, or the Salesforce red team found with Meat Pastel. Okay, if you have a formal recognized protocol to follow, you don't have to ad lib the entire process of deciding how, when, and I would say whom to disclose that particular thing. And instead, you can point to a well regarded standard and say, this is the structure that we are abide by. And we notify the stakeholders within X days, like 15 days, 20 days, 30 days, or something like that. So we release a partial technical details under these conditions, and we keep a record of of every communications. Like by having such a roadmap, you're not just making life easier for yourself, but you're also, I mean, showing regulators, courts, and even the internal legal departments that you took a responsible codify approach, right? So moving to the next, no, first we'll talk about yes, moving to the next. Let's say. So first, let's talk about the COBIT. I mean, Asaka framework. I mean, you may heard of COBIT. I mean, somewhere on the internet. A framework that helps to align IT governance with overall business objective, placing like a strong emphasis on auditing and control. So Azaka also offers certifications such as CISA, Certified Information System Auditors, and and so on. So if you are conducting a major forensic investigation or a risk assessment, and you happen to be a CISA certified, right? It is a signal to your clients or your employees that you are following a methodology rooted in the globally recognized best practices. Okay, on this earth. So people sometimes forget that certifications come with ethical codes. For instance, uh, an Asaka certification included communication to, I mean, integrity and confidentiality, which can become critical if you have to justify how you handle a vulnerability disclosure. Okay, next we'll talk about ISO. Okay, so most notably ISO EC 27001 focuses on establishing an information security management systems, ISMS. Okay, so while the ISO zeroes in on risk management, I mean, this might sound a dry in theory, but in practice, they are powerful. Okay, literally powerful. So they require you to, I mean, classify the assets like the Bluetooth logs on a malware generation tool, evaluate the I mean, threats based on the likelihood and impact, and then I would say ensure there is a continuous improvement loop. So, in a simple terms, I would say ISO actually encourages organization to avoid a one and done security postures, and instead you keep refining your controls, and checking for the new vulnerabilities and documenting how you responded to them. If a lawsuit or a regulatory inquiries arises, I mean, the organizations can show the consistent methodological steps taken in the ISO rather than the I mean, I would say haphazards or reactive measures. So that is the best thing about ISO. So that was all for the ISO standards. So finally, there is a NIST cybersecurity framework, CSF. So NIST is actually widely used in United States and increasingly recognized abroad. So as its core five functions: identify, protect, detect, response, and recover. I mean, each function breaks down further into subcategories. Like under identify, for instance, you would systematically locate all the digital assets, servers, IoT devices, and networks, and any associated vulnerabilities under under that. And for protect, you would implement layered defenses. And under detect, you would deploy monitoring and anomaly detection tools, like in response, spell out exactly what happens when incident occurs. And recover focuses on how to return the operation to normal with minimal fallout. So it's easy to see how either the Bluetooth locker scenarios or the meat pistol scenario might have been handled more smoothly if the organization had a well-defined guidelines, like from NIST triaging vulnerabilities or deciding how to responsibly inform others to the all potential risks over on internet. So my question is, why standard measures? Okay. So professional standards aren't just, checklists. I mean, they serve as a legal and ethical safeguards. And if you're a forensic investigator working on, so say a date of a breach, and a plaintiff challenge your method in a court. So you can point to your adherence to a recognized framework to show that you followed the established best practices. So this doesn't mean like you are immune to, to lawsuits, and show that you followed the established best practices, right? But it actually does strengthen your defenses by illustrating the reasonable accepted approaches. And furthermore, many frameworks carry ethical codes that require ongoing professional development, ensuring that the practitioners remain current with evolving threats. I mean, new case laws and emerging technologies like AI, IoT, and Web3s. So the benefit is twofold. I mean, for one, it reduces the risk of personal liabilities if you can demonstrate you followed the widely respected playbooks, and for another, it fosters consistency in how organizations handle everything for the vulnerability scanning to incident response, from the top to bottom, or we can say from the bottom to the top. So instead of each security team inventing its own rules on the fly, and potentially landing in a legal hot water like Anthony Rose on and I'll say Salesforce rating, and their employees and managers can rely on the consistent, transparent protocols. So for now, that was all for the nest, and here we'll start our case study: AI in legal practices. Okay, Drummond and Cadillac Fairview. So I would say let's look at how artificial intelligence is finding acceptance in the courtroom by the examine. I mean, Drummond and Cadillac Fairview Corporation Limited. It was in 2018, if I remember. Okay, so below I have highlighted a few things, like I mean, all these things will show like how everything went. Okay, so in Dumont versus Cadillac, sorry. So in Dumont and Cadillac Fairview, the initial lawsuit was about a personal injury. Okay, a classical slip and fall scenario in a mall setting. So ordinarily, we would expect the legal tussle to, sorry, to resolve around negligence or premises liability. So instead, this case took a fascinating turn when the parties disrupted the legal costs, specifically the fees associated with using the computer-assisted research tools such as Westlaw. Okay, so the plaintiff argued that a modern legal practices often depends heavily on these databases, and the court took opportunity to comment on their necessity. What began as a routine liability question, questions unexpectedly become a milestone for how the judiciary perceives AI and advanced research tools in everyday legal work. Okay, so the court's stance. okay, was unambiguous, I would say, and it actually deemed AI driven or database driven legal researches to not just a luxury but a necessity for of modern practices. Okay, that's a strong endorsement, I would say, and essentially it said to all parties involved, yes, these tools are integral. You can recover the costs if they are used reasonably, and by billing and recovering costs for the computer assisted research, the code sent a message that advanced tool have become entrained in the fabricated or legal diligence. It's like saying in a today's day and age, no serious legal professional can expect it to do a job without them. Okay, so this actually goes beyond the awarding fees. It's a reflection of how the legal systems can adapt to technology. I mean, if a judge is comfortable treating Westlaw or AI-powered search or research, okay, that actually suggests an overall, I mean, willingness to trust such a tools and see them as integral to best practices. And for cybersecurity professionals who might use AI in a digital forensics, I mean, this could pave the way to codes to be more open to your methodology and potentially to avoiding the cost of advancing the the investigative softwares if you can show it was essential to your works, right? So next we'll talk about the implications of cybersecurity. So here's the one question: why does the slip and fall case matter to cybersecurity? Okay, because it actually shows the judiciary's readiness to embrace how technology, especially if it leads to more efficient or a more accurate results. So when a court explicitly states that advanced tools are not just acceptable but vital, so it broadens the door for other AI applications, okay, such as automated malware analysis or AI based threat detection tools. So if you're a security researcher or a forensic examiner, you can point to the Tomorrowland case as a sign that the legal system will recognize how technologies underpins modern investigation processes. Okay, so consider a scenario where you use an AI-driven platform to, I mean, shift through the gigabytes to network logs for a sign of a breach. Okay, if an opposite counsel questions your method, you can argue that that relying on such tools is actually anonymous to using the best laws or for legal research. It's validated, and a modern solution that that actually yields to timely and reliably with results. Okay, so Drummond is far from all the encompassing precedent, but it's indicative of legal culture, right? To evolve and the meat of logical realities. So this was for the judicial president. Next, we'll talk about the cost recoveries. So one practical angle here is cost recovery, or we can say cost dimension. So when you rely on AI-based platforms, so whether it is for e-discovery, for triaging a network intrusions, or for analyzing devices logs, I mean the system licensing and computations overhead can be substantial and enormous. So Drummond versus Cadillac Fairview shows that if if a court sees these tools as essential, it might be willing to classify related to expenses as a recoverable. So this is a big deal for expert witnesses. I mean security constraints and even in house of a security teams who often build and track the cost of specialized technologies, right? Sorry. So it doesn't stop at reimbursement though, and the broader implication is that judges increasingly view the advanced technology as an integral part of the reasonable component practices. And if you end up with explaining your investigation costs, uh, you may have an easier time justifying them. If you can demonstrate your methods align with the recognized best practices of using the AI large scale automating tools and analysis. And on the other side, on the flip side, if you choose not to employ such technology, an opposing party might argue your methodology was incomplete. Okay, so courts might not only allow these costs, but eventually come to expect them in high stakes cybersecurity cases. Right. Moving to the next, it's future of AI and cybersecurity. So while confirms that AI-based research is uh, is generally seen as legitimate and necessary, it's still early days. So looking forward for the question becomes like, it actually, I mean, how do we handle the transparency and the potential biases in AI algorithms? So if you're using machine learning to pinpoint like a suspicious activity or generate a timeline of an attack, so opposing counsel might want to know how your system was trained, whether the data is balanced, and how the algorithm decides to what is suspicious and what is not. So, even as a benefit from the broader acceptance, we should expect to meet demand from explain the AI, a concept that ensure the decision made by AI are traceable and untraceable. Okay, and next is the synthesis and the conclusions. Okay, our last topic. So, bringing all these points together, uh, we see how Anthony Rose's decision discloses Bluetooth log flaws and the Salesforce Red Team's attempts to publicize the meat pistol. Both highlights real tension over here that actually arises whenever security professionals venture like beyond quiet in-house fixes. Okay, sorry, my bad. I mean, the presence of professional standards those from Azaka, ISO, NIST helps to mitigate the conflicts by offering recognized procedures for risk management, I mean, vulnerability handling, and forensic analysis. And at the same time, the increasing role of AI in the legal practices points to a future where advanced tools might facilitate everything from e-discovery to incident response, and yet also brings novel legal and ethical challenges around the transparency and the biases as well. So ultimately, good intentions alone may not suffice if a researcher or employee lacks the legal the legal cover and the procedural clarity. These frameworks offer as I mean, neither Anthony Rose nor the Salesforce employees were necessarily acting maliciously. I mean, they were simply caught between their own sense of responsibility and the real of a perceived legal rights of manufacturers or employees. Okay, so the solution often lies in bridging these gaps early with coordinated disclosures, okay, about internal policies, the consistent adherence, recognized standards. So, professional codes of ethics can further strengthen the position of those who take escalation step by step. Okay, documenting their justifications, the synergy of laws, ethics, and industry standards remain essential for forensic investigators and cybersecurity professionals, particularly as AI and the new technology rewrites the rule book on what is possible. And if there is one takeaway, okay, Uh, if it is that navigating cybersecurity law and ethics requires a disciplined methodological mindset. We must remain aware of legal statuses, that the legal statutes that applies, and respect the intellectual properties, and corporate the confidentiality, and simultaneously honor our duties to protect the public from preventable harm. So, by anchoring our decisions in established standards, we are far less likely to be viewed as a reckless or adversarial, and more likely to be recognized as a professional and advancing their security for everyone's benefit, I would say. So that was all from my side. Thank you for listening this talk of vulnerabilities and legal constraints, ethical dilemmas, and yep, AI. So I hope this presentation clarified some of the key dilemmas and offered insight into how to best tackle them. I'd be happy to address any of the questions of further discussions on this point. So comment below on the comment section if you have any kind of questions. Thank you so much.